Good morning, well, good afternoon for me already, or good evening, wherever you are. That seems to be a new way of introducing ourselves in these new times, but it's really excellent to have you all with us for this panel session on the application of the Refugees Convention's cessation provisions, new practices of temporary protection, ? So my name is Cornelis or Kees Wouters. I am the Senior Refugee Law Advisor at UNHCR, working in the Division of International Protection in Geneva, Switzerland. And it's really a pleasure and an honor to moderate this session. Before we get into the swing of things, allow me to remind you of some housekeeping rules and to explain to you how we will run this session. We have for you four very distinguished speakers who will give their perspective on the theme for approximately 10 minutes. And after that, we'll open up the floor for questions from you guys. Please pose your questions in the chat, addressing it to whoever you want to address it to. And then we'll open up the floor again to the presenters to respond to your questions. Please keep your cameras and microphones off, except obviously for the presenters when they're speaking. I should also remind you that this session is being recorded, and if you do not wish to appear in the podcast, I kindly remind you to leave now. So today's session on the Convention's cessation provisions and whether whether we see new practices of temporary protection is an important question. Cessation has long been maybe even ignored in many respects. The International Refugee Protection Framework, I guess, is premised on the notion that refugees are in need of international protection until a solution to their problem of being a refugee is found. And the need for international protection arises and continues to exist when a person is outside its own country and unable to return home because they will be at risk of persecution there, and that country is unwilling or unable to provide protection. Now, the need for international protection as a refugee under the 51 Refugee Convention should not ideally be permanent, but rather temporary until they no longer need international protection. So this is the case when national protection is again available or when it becomes available and international protection as a refugee can seize. Now, the 1951 Refugee Convention recognizes this and recognizes that national protection can be found in the country of origin because the refugee can safely and durably return or has returned to that country, or because it can be found in a third country where the refugee has obtained a new nationality, or finally in the country of asylum through integration and eventually naturalization. But until such time national protection becomes available again, contracting states to the 1951 Refugee Convention are obliged to include refugees in their national systems, to accord them access to a whole range of rights and provide them with a secure legal status, authorizing them to stay, realistically allowing them for rights to be respected, protected, and fulfilled. Now, cessation should, in my view, be applied with caution, bearing in mind the solutions context in which it operates. Cessation should not result in refugees residing in the host country with an uncertain status and should not be applied before a durable solution is found. Our four presenters today will make critical observations on the increased application of the cessation clauses, and I guess the uneasy relationship that cessation has with durable solutions, particularly integration and resettlement. They will be asking whether the application of cessation by states is indeed a new practice of temporary protection. With these words of introduction, allow me now to introduce you the first speaker of our panel, Dr. Jessica Schultz. She's a senior researcher at the Christian Michelsen Institute and a postdoctoral researcher at the University of Bergen in Norway. She's a lead researcher for the project TEMPRO, which looks at the dynamics and the effects of temporary protection on refugees in Norway, Denmark, Germany, and the UK. Now, Jessica will speak on cessation and the surrogate role of refugee protection. Jessica, over to you. The floor is yours.
Thank you, Kees. It is a delight to be here and to talk about a topic that has been occupying me for the past year or so. My presentation is inspired by relatively recent emergence of regular cessation practice in Northern Europe, the region which is the focus of my work on the Tempro project. Increasing the insecurity of refugee status is one of many tactics that have been deployed to deter refugee arrivals, and one measure in this regard is the introduction of safe return reviews, an intensified cessation practice through which a refugee's continued need for protection is reassessed either at certain points in residence or at the initiation of authorities when conditions in a particular country have changed. Through the lens of the Farida II judgment decided by the Norwegian Supreme Court in February, I'll raise questions about how cessation practice has evolved by looking at the court's specific interpretation of refugee law's surrogate role. As Kees mentioned, our Article 1C sets the parameters for potentially withdrawing refugee status. The ceased circumstances clauses in paragraphs 5 and 6 state that cessation may be applied when circumstances in connection with the grant of refugee status no longer exist. As UNHCR notes, these circumstances principally refer to the political and basic human rights conditions in the country of origin or habitual residence. The key here is that the refugee no longer has a well-founded fear of persecution, and the changes eradicating that fear are fundamental and durable. Obviously, a general problem that arises in state practice is the premature return of refugees to countries which are still affected by conflict. But recent Norwegian practice illustrates three specific issues that so far have received considerably less attention. The first relates to the reliance on an internal protection alternative, or IPA, as the basis for withdrawing refugee status. In other words, even if a refugee's previous home area remains insecure, states will apply cessation based on other safe areas in the return country. The second is application of cessation to changes in personal circumstances. In contrast to changes related to the general conditions in the country of origin, for example, a change in government, changes in personal circumstances often relate to gender-based harms, age-specific exposure to risk, marital status, sexual orientation. So you see in Sweden and Norway that unaccompanied minors who age out of that status are exposed to cessation, as are single women who are reunited with their partner or marry. Application of the cessation clauses to personal circumstances is qualitatively different from the types of situations which the cessation clauses typically address. And the third dimension or dilemma relates to the reliance in these decisions on non-state actors, including family members, as providers or co-providers, at least, of protection. So the Farida case. The Farida story, which has been extensively covered in Norwegian media, started a decade ago, in 2011, when an Afghan woman and her daughter Farida arrived in Norway after being separated from Farida's father in Greece. They received refugee status because of security risks in their home area in Ghazni province and the lack of effective protection elsewhere in Afghanistan without a male companion. When Farida's father later showed up in Norway, she and her mother received notice that refugee status would now be withdrawn based on the fact that they could safely return to Afghanistan. After years and years of litigation, in 2020, the Court of Appeals found that refugee status was legitimately withdrawn based on an IPA in Kabul. The previous obstacle to return there, the absence of a male network, no longer existed now that the family was reunited. And it was this change, not the security situation, that was identified as significant and stable. The relationship seemed robust. When it came to security, the court found that despite continued attacks on civilians in Kabul, return there did not pose a new risk of persecution, inhuman, or degrading treatment, nor was there a threat of being forcibly removed back to their previous residence. The decision was then appealed to the Norwegian Supreme Court, which considered the principal issue of whether the IPA is compatible with the cessation analysis. The family, together with UNHCR, argued that cessation is really about the absence of risk that gave rise to refugee status. The IPA is principally incompatible with cessation because it suggests that changes are neither fundamental nor durable. Protection for the purpose of cessation also includes considerations of general security and rule of law in the country of origin. On the other hand, the state, and here the court agreed, argued that when refugee status is granted, at least in part on the basis of personal circumstances, a change in those circumstances, which means that protection is once again available in the country of origin, is sufficient to cease refugee status. That means that return to an IPA is relevant. The logic of this judgment can be understood through the specific interpretive lens applied to refugee law in Norway, which foregrounds its subsidiary or surrogate role vis-a-vis the duty of protection owed by a state to its citizens. Of course, it's uncontroversial that international protection is triggered by a failure of national protection, as established by Articles 1A, 1C, and 1E of the Convention. But there is, as many others also in this conference have pointed out, a big difference between the descriptive use of this embodied metaphor of surrogacy and its application as an interpretive framework or principle. In the latter case, the absence of state protection anywhere arguably becomes the condition of refugee status. We also see in practice that surrogacy arguments justify a shift in focus away from a person and her well-founded fear and towards generalized assessments of in-state protection. In the Farida case, the circumstances related to the recognition of refugee status, which includes the threat of violence in their home area, are subsumed by the reasons for recognizing refugee status, which include the IPA assessment. This is a subtle but really significant difference. The feminist geographer Doreen Massey reminds us that places are articulated moments in networks of social relations and understandings. Places of protection, especially in the cessation context, have temporal, social, political, and geographic dimensions that are excluded from the seemingly neutral narrative framing the Convention's purpose as providing backup protection. So if we look at this place of protection that Farida and her mother inhabit, it's situated in a city still affected by violence targeting civilians. Any protection that is available is mediated through private relationships. The automatic provision of protection for women without male partners and the automatic loss of that protection when they are reunited obscures, as feminist scholars point out, the myriad ways in which families, particularly in situations of conflict, displacement, and stress, may be a source of harm and constraint. The court's logic, focused on the absence of foreseeable risk, dismisses the fragility of state protection, the fragility of family protection, potential harms of internal displacement, the effects of trauma and past violence, including during flight, and constraints on mobility. In other words, it ignores the important dimensions of human security and not least national membership that animate the Convention's concept of a durable solution. The consistent threat of cessation of status, meanwhile, has consequences for the inclusion of refugees in the country of asylum. So to conclude, I think as researchers of refugee law, one role we have is to challenge the transnational dialogue among courts and scholars that we see in Northern Europe, and that reinforces certain interpretations and not least certain interpretive frameworks. In other words, we can question or at least illuminate the power dynamics that, to paraphrase Obiora Okafor, shape meaning, normalize behavior, and make the normal normative. This requires us to go beyond what I've just done here, which is to critique current state practice, to question received wisdom, and not least it requires us to explore harder to access state practice, and not least the absence of practice. As our books on treaty interpretation remind us, we can't assume silence to be acquiescence, And yet often it's only the detailed legal analyses published by a handful of jurisdictions that count in these discussions about the developments, particularly restrictive ones, in refugee law. With that, thank you. I look forward to your questions and comments.
Thank you so much, Jessica. Thank you for taking us to Northern Europe and highlighting some of the important challenges, I think, that we're facing and that the Refugee Convention is facing. So it fits very well in the overall theme of this conference. What may seem as a minor issue, international protection alternative, is actually turning into a very big problem, if you will. So thank you for that. I'm moving now to the next speaker, Maria O'Sullivan. Maria is an associate professor in the Faculty of Law at Monash University in Australia. So it's a great pleasure to have you here, Maria. I must be late in the evening where you are sitting. You're also a member of the Castan Center for Human Rights Law, and your recent publications include refugee law and the durability of protection, temporary residence and cessation of status. So a very fitting book for this panel. You are currently undertaking a series of research projects relating to artificial intelligence and the law, including the human rights implications of border technologies and surveillance. Maria will speak on cessation of integrated refugees, a humanitarian approach or recognition of social citizenship. Maria, the floor is all yours. Thank you.
Thank you, Kays, and thank you to Jessica for that great discussion. Jessica's done some really wonderful work on internal protection alternative and cessation. And thank you to Kays for mentioning the importance of durable solutions. So what I'm going to do is look at the other side of cessation, where the state is seeking to deport the person who's had cessation applied to them. So obviously we know that there has been a rise in temporary residence permits. And of course, some of this practice comes from Australia, where I'm based. We now have rolling temporary visas. Back in the 90s, we did have temporary protection visas, but they did ultimately lead to permanent protection visas. Now for boat arrivals, we have what's called temporary protection visas, which are rolling. For boat arrivals, they never can get a permanent protection visa. So this raises all sorts of issues for this idea of a durable solution. The situation in other countries, like in Europe, is not quite the same. But again, we have this problem in using temporary residence permits, which are linked to refugee status or subsidiary protection as well. So what I'm trying to look at here is, I guess, the second point is about what do refugees do in practice? And in practice, they do establish integrative links to the asylum host state. So if that is happening in reality, how should the law reflect that practical reality? And I've given some examples there. Jessica also mentioned that idea of marrying and personal relationships. So that may occur. The person, particularly if they're in the host state for 3 or 5 years, may start a family, purchase a house, or even become involved in the activities in the community. So how should this be reflected in the deportation cessation assessment? And of course, Article 34 of the Refugee Convention is relevant. I know that there is a lot of, not so much criticism, but a discussion about the weakness of Article 34, and it does not set out a concrete obligation. It says, as far as possible, facilitate the assimilation and naturalization of refugees. So it's not a strong obligation, but it's still a recognition that states should try and naturalize refugees. Now, whether that's by way of some permanent visa or whether it's citizenship, there has to be some legal recognition of their settlement. Now, I recognise that states can deport former refugees once a person with refugee status has that status revoked. They are then a non-citizen, or whatever the status is in the relevant country. My argument, though, is that the governments that try and use cessation are very much looking at a black and white approach where they say, well, you're no longer a refugee, so you can be deported. My argument is that it's more complex than that because of these integrative links. And I do think we can use Article 34 and also the acquired rights framework in the Refugee Convention to constrain that power. So just briefly, we have some state practice. In Germany, the authorities have said that a decision about cessation and deportation must take into account personal reasons. For example, you can look at the length of stay, the degree of integration, the person's employment situation, and also family ties. In Belgium, the authorities tend to look at the level of integration of the refugee when they look at cessation. However, others do set a very high threshold for permanency. So, for example, the Immigration Appeals Board of Norway has said that there has to be some special cause related to previous persecution. So again, the link is to persecution rather than a general examination of the integrative links. And it's interesting that Jessica was talking about Norwegian case law because there is a lot of interesting cessation jurisprudence from Norway, also from Denmark as well. So I think we need to establish a lot more consistency and guidance on this issue because I think there is some state disparity which is unwelcome. So my central arguments, and again, I'll give a plug for my book and also a shout out to Professor Susan Kneeburn, who is hopefully in the audience. This is based on my thesis and Susan was my PhD supervisor. So in the book, I do argue that the application of cessation needs to better reflect how temporary permits operate in practice. So, for example, in Australia, if someone is on a rolling temporary protection visa and they may exist in Australia for 7 or 8 years, then I think that clearly meets the threshold of settlement and integration, and that absolutely does have to be reflected when the deportation decision is made following cessation. So in my book, I draw on a wide array of citizenship literature, which is very rich. And I argue that citizenship is not just a legal status, it can also include social membership. And so my argument is that recognised refugees on temporary residence permits are different from asylum seekers who are applying for refugee status. The difference, I guess, is that recognised refugees have been shown to have refugee status. They've got an established case for persecution. And also the integrative links that they make to their host state gives rise to an identity which is like citizenship. Now, other commentators have sort of referred to this general argument. For example, Luke Lee, who's written a book on consular law and practice, notes that through the grant of asylum, a refugee enters into a special legal relationship with the state of asylum, similar to that of nationality. And of course, we can see that in the way the acquired rights set out in the convention, the Refugee Convention, that is, are set out. You know, there is a link to what other nationals are treated. Cairns, who's written a lot on immigration, also talks about individuals who are living in a society over an extended period of time and therefore can become members. He talks about, you know, passing a threshold that entitles them to virtually the same legal status as citizens. And he gives 5 years as an example. Other commentators like James Hathaway have also referred to this 5-year period. So some conclusions, questions, and provocations. So I recommend that integration by refugee in an asylum host state must be considered in the cessation and deportation decision. I do think that greater consideration must be taken of the Article 34 Convention principle. Also, the acquired rights which are granted to refugees that reflect the increasing linkages that refugees make to the asylum host state. There are different terms in terms of lawfully present, lawfully staying and resident. And of course, James Hathaway has written on that very issue. So in conclusion, I think there should be a social membership status of long-term resident refugees. Now, of course, that's, perhaps a theoretical argument, and you might be saying, well, in practice, how are states going to respond to that? And some provocations and issues for consideration in the chat may be, firstly, will this requirement deter states from granting refugees any sort of protection in the first instance if they have to give permanency after a period of time? And I know, again, others have written on that issue. Should the relevant period be 3 years, 5 years, or 7 years? Thirdly, and this is an interesting issue, particularly with the aging out problem, should particular consideration be made as to whether the stay in the asylum host state was during the person's formative years? And I believe there should be greater consideration of that, even if they have aged out. Fourthly, should consideration be given to the fact that a significant period of residence in the asylum host state may in fact affect the capacity of the refugee to reintegrate into their home country? And that again may be relevant to number 3 about the person's formative years being in the asylum host state. And then fifthly, going back to the point that Kay started with at the start of this session, are temporary residence permits actually a durable solution? Thank you, everyone.
Thank you so much, Maria. I think an excellent presentation that shows us the reality, I guess, of many refugees and the links they have with their host country, the host communities they find themselves. I'm also pleased, certainly personally pleased, that you are invoking Article 34. I think despite its inherent weaknesses, it is an article that needs to be looked at much more closely, especially in the context of the discussion that we're having today. So thank you so much for that presentation. Right, moving on, our next speaker is Nicholas Feith-Tan. He's a senior researcher at the Danish Institute for Human Rights, specializing in asylum and refugee law. Now, Nick will speak on cessation in the shadows of the convention, focusing on complementary protection, again, integrative links and solutions. Nick, the floor is yours.
Thanks, Case. Lovely to be here. I think I've had the pleasure of attending all 5 of the RLI's annual conferences, so it really is excellent to be back, albeit in this virtual format. Many thanks to Jessica for organising, and again, Case for chairing this really excellent and timely panel. As you mentioned, my paper is entitled Cessation in the Shadow of the Convention, reflecting the fact that complementary protection holders are not necessarily protected by the high bar set out by Article 1C of the 1951 Convention, and indeed the Articles 2 to 34 relating to integrative links. I've also chosen to abandon my PowerPoint, inspired first by David and second by Jessica. So I'll just speak to camera for my 10 minutes. And of course, perhaps not surprisingly, my paper takes its point of departure in the case of Denmark, which has recently refused to extend residence permits for Syrian complementary protection holders from the Damascus province. And this will probably not be news to many of you. It's really made both Danish but also significant international headlines in the past weeks and months. And while I'm going to draw on the Danish case rather extensively, I'd suggest to you at the outset that while Denmark is certainly a front runner in this practice, it may not necessarily be an outlier, and time will tell. And this work is of course inspired by the late Joan Fitzpatrick on both cessation and temporary protection. So what I'll do in my 10 minutes is briefly outline the legal basis for Denmark's cessation practice and then raise 3 substantive legal research and policy issues for your consideration. The first, of course, is my claim that there is a potentially rather significant divide between cessation standards for convention refugees on the one hand and complementary protection holders on the other. Secondly, I'm looking into the extent to which Article 8 of the European Convention on Human Rights, which protects the right to private and family life, can form a sort of protective backstop for complementary holders subject to cessation. And finally, I'll offer some brief reflections on the uneasy relationship between cessation and solutions for refugees, both as a matter of law and of practice, which I believe Melton will pick up vis-a-vis resettlement. So firstly then, you would probably be aware of Denmark's self-proclaimed paradigm shift in the area of refugee protection. The legal story of this so-called shift dates back to 2015, when the Danish Parliament introduced a new temporary protection status through the insertion of Article 7.3 in the Aliens Act. And this status carves out a particularly thin form of protection for asylum seekers not fleeing an individualized form of persecution or serious risk, but rather a generalized form of violence in the country of origin, including Syria. So in the creation of this law, there was, of course, a rather narrow focus on Article 3 obligations, and quite explicitly, once the human rights conditions in the country of origin are even slightly improved, protection can be withdrawn, even when the situation remains serious, fragile, and unpredictable. The second step in this paradigm shift was a further amendment in 2019, when the Danish Parliament adopted further legislative changes, making all refugee protection temporary as a point of departure. So under this approach, immigration authorities must end the protection of refugees unless it would breach Denmark's international obligations. So these changes have obviously moved Danish refugee policy away from a sort of assumption of permanent protection and integration that Maria's touched on towards temporary protection and return. And in human rights law terms, of course, the debate has quickly moved to focus on Article 3 questions with respect to the situation in Damascus and Syria more broadly, and of course, Article 8 obligations with respect to integrative links in Denmark. A further notable aspect of the Danish practice is the rather long cessation window of 8 years before which a person can gain permanent residence. And I should note, of course, that the practice so far vis-a-vis cessation and non-extension relates almost exclusively to firstly Somalis and most recently Syrians. So my claim here, moving towards a more normative consideration of cessation standards, my claim here is that the Danish case points to a gap in the protective framework vis-a-vis complementary protection. So while refugees on the 1951 Convention benefit from this rather high bar of Article 1C, 5 and 6, where ceased circumstances to be invoked by the asylum state must only relate to changes that are fundamental, stable and durable. In this case, we see a very, very narrow focus on rather thin Article 3 obligations. On the other hand, of course, Articles 16 and 19 of the EU Qualification Directive provide an almost identical form of protection to subsidiary protection holders, with changes being significant and non-temporary in nature where cessation is considered. And my claim here, I guess, is that the Danish case indicates that a cessation framework based entirely on human rights law, that is non-refoulement essentially, is insufficient. And for legal certainty in these situations, a more detailed human rights-based cessation framework for complementary protection holders should be undertaken. My claim here, in essence, is that the absence merely of a risk of refoulement should not be a sufficient basis for the ending of protection, notwithstanding its fundamental role in granting it. So to move away then from Article 3, I want to look briefly at Article 8 questions, and noting once again that complementary protection holders do not benefit from the integrative rights contained in Articles 2 to 34 of the 1951 Convention. And what I'd suggest here is that the Danish case raises some questions as to the protective scope of Article 8. So we know, of course, that with regard to expulsion cases, the European Court of Human Rights balances the interests of the member state on the one hand against the rights of the applicant in assessing whether the interference with the right to family and private life is proportionate to the legitimate aim identified, in this case, migration control. And of course, while a significant volume of jurisprudence does exist on this Article 8 question, vis-a-vis expulsion, crucially, to my knowledge, all case law currently concerns irregular migrants with no protection status, or indeed other categories of migrants who have conducted some form of criminality and are thus subject to deportation. So this leaves open the question of whether Article 8 can offer any protection from cessation and subsequent expulsion in the case of former complementary protection holders. And with respect to the right to family life, of course, we have seen in Denmark that cessation practices includes the splitting up of families where young adult children, for example, have their protection ended while their parents retain residence permits. And I should note here that the European Court of Human Rights has recognised the existence of family life between parents and adult children where there are additional elements of dependence. The court has further found that in some cases where young adults have not established a family of their own, they may share a family life with their parents. And briefly again, with respect to the right to private life, cessation practice also raises the question of when integrative links in the asylum state offer some level of protection from cessation and eventual expulsion. The leading case, of course, is Maslow versus Austria, where the European Court held that, and I quote, "For a settled migrant who has lawfully spent all or the major part of his or her childhood in the host country, very serious reasons are required to justify expulsion." It's worth noting, however, that Maslow concerned the expulsion of a migrant, again, with a criminal background, raising the question of whether complementary protection holders should indeed receive a higher level of protection under Article 8 due to their lawful stay in the asylum state. Moreover, in some contrast to Maslow, Syrian protection holders in Denmark have been in the country for only 5 to 7 years. So there is this rather open question, in my view, whether the grave interruption with private life can be balanced proportionately against the state's objective to carry out migration control. And I should note here that I'm considering a rather longer piece of work on this Article 8 question in particular, so welcome any and all comments. And finally, in my remaining couple of minutes, I'll just touch briefly on the relationship between cessation and solutions, which of course is a key theme of this panel. I think, in short, there is a rather significant need for further research, which I think Jessica also pointed to evaluate both the practice and the efficiency of cessation practice vis-a-vis solutions. So in particular, the relationship between cessation and protection on the one hand and eventual voluntary or forced repatriation on the other requires investigation. Existing work, I would say, suggests that the number of people who actually return, at least in the Nordics, are very low. Of 3,000 protection holders subject to cessation and revocation review in Norway, for example, in the recent years, only 5 people returned. Of the 800 Somalis who've had their protection revoked in Denmark, only a few dozen have in fact returned home. And indeed, I've spoken with journalists very recently who are aware of Syrians already moving from Denmark to Germany, either because of cessation or in anticipation of such. And of course, in the Danish case, perhaps most tellingly, there is no current mandate for forced return of Syrians from Denmark. So it seems the government is essentially betting on the uptake of voluntary return programs. As a result, I think, at least from existing knowledge, we can state that state-mandated cessation does not automatically result in voluntary or indeed forced return. And cessation seems more likely to place former refugees, former complementary protection holders in a situation of uncertain legal status, unable to integrate and unable or unwilling to return home. Thank you very much.
Thank you very much, Nick. Thank you for, I guess, introducing complementary protection holders, their situation and their situation in terms of protection statuses, the narrow focus that they are often, and certainly in Denmark now, receiving, where in essence the focus is on whether there still is a refoulement risk. Also highlighting kind of the question how their situation differs or not differs from those that have received refugee protection. Their integrative links, the same integrative links that they have compared to refugees. Of course, I guess a complicating factor when it comes to complementary protection holders, certainly in the context of Denmark or Syrians in Denmark, is that you can ask the question whether in many of these cases these people should not have received refugee status rather than a complementary form of protection. Invoking Article 8 of the European Convention on Human Rights, the right to family life in particular, is an interesting one and certainly something that I think needs to be pursued in the case of Syrians losing their status in Denmark. I'm quite happy to see that the chat is going well. Many questions are being posed, and I'll urge you again to let your questions come into the chat to specific panelists or to all panelists. Let's now move on to the last speaker of our panel, Dr. Meltem İneli-Çiğer. She's an assistant professor at the Süleyman Demirel University Faculty of Law in Turkey. She holds an LLM and a PhD from the University of Bristol, and she's currently working as a researcher and beneficiary university coordinator of the Azila Project. She works on international European and Turkish refugee and migration law. Now, Meltem will speak on resettlement. Has resettlement become a temporary solution? An analysis in light of the European Commission's proposal for a regulation establishing a union resettlement framework. Meltem, over to you. Thank you.
Thank you, Kees, and it's a pleasure to be, as Nick mentioned, to be in the RLI conference. Hi all. Today I will try to find an answer to a question that whether resettlement has become a temporary rather than a durable solution. I know it comes as a strange that one of three classical durable solutions, resettlement, and trying to associate it as something temporary, but I'm sure when you hear my reasons, perhaps you have some reason to understand where I'm coming from. So I hope you can see my PowerPoint slide. Today I'll be talking about, and this is, I must say, this is also included as part of the Azila project now funded by the Horizon 2020. Starting with resettlement and international law, I'm sure that most of you in this room already know, but there is no international structured legal framework governing resettlement or specifying responsibilities of states in relation to state resettlement. And as a result, states get to decide if and who and how many persons to resettle. And still, as a result, there are many divergencies between national resettlement policies and practices, especially with regard to the selection criteria, which includes eligibility and exclusion, determination and criteria, resettlement procedures, whether the resettlement mission would be done on the file basis by reviewing files or through interviews, the length of procedures, the status granted to resettled refugees in the resettlement states, and when this status and if this status can be withdrawn. So when I had the idea, and I must say Nick's recent paper about cessation in Denmark has been a great inspiration. One of the questions I had in mind was what makes a particular solution a permanent or a durable one? So when I reviewed the literature, I found some sources, some really helpful sources, but there is no unified view on what makes something a permanent or a durable solution. Now, according to UNHCR, this concept is closely related with refugees having a permanent ties or permanent protection in the host state or the resettlement state. And for instance, Professor Hathaway's book's new edition mentions that when refugees access to durable solutions, they no longer need the surrogate protection. So when they have access to durable solutions, ideally refugee status should come to an end. There are also other authors who argue that durable solutions are closely connected with citizenship, acquiring citizenship in the host state or the resettlement state. But there are also others equating durable solutions with having rights similar to those of nationals of the resettlement state. So I cannot say there is only one answer to this question, what makes this particular solution a permanent or a durable one. But my conclusion from this literature review is that I think I'm aligning my argument with that of UNHCR's, that I concluded that when a refugee receives a permanent status in the resettlement state, be it permanent residency or citizenship, and he or she doesn't need to look for a surrogate protection anymore, this means he or she has access to a permanent or durable solution. Now, if we take this view, or this is mostly UNHCR, we've promoted in 2011 UNHCR Resettlement Handbook, I realized there must be 3 questions to ask to determine whether a certain resettlement policy or practice provides refugees and other persons who are in need of international protection a permanent or a durable solution. First, we need to see who gets resettled. Ideally, and mostly classically in practice, especially through UNHCR auspices, refugees as defined by the 1951 Convention, especially those who fall into the vulnerability categories and UNHCR resettlement categories, would qualify for resettlement. And when we look at the status or the rights they get in the resettlement state, UNHCR advocates that resettled refugees should get permanent residency and have access to civil, political, economic, social, and cultural rights similar to those enjoyed by nationals in the resettlement state. And ideally, this should not be withdrawn for no reason, and this status or the enjoying rights should be as permanent as possible. So I accepted these 3 criteria as a benchmark for measuring whether a certain resettlement framework or policy provides refugees a permanent solution. And with these criteria, now I would like to, and in my paper, I examined the 2016 EU Commission proposal for regulation establishing a union resettlement framework. Now, you may think this is quite old. It was 6 years ago that the Commission tabled this proposal. But I must tell you that in last year, in the European Agenda on Migration and Asylum, the Commission once again urged for the swift adoption of this proposal and did not change anything on it. So when we look at this proposal, perhaps you have seen it before, but it is not quite a recent development. So I would like to remind you that the proposal seeks to create a more structured, harmonized, and permanent framework for resettlement across the EU. And in line with this objective, it introduces common and unified selection, eligibility, and exclusion criteria, resettlement procedures, and it has provisions on how to establish this union resettlement framework. Establishing the framework has 2-step processes. So first of all, the Council is to adopt an annual union resettlement plan, which should include the overall number of persons who should be resettled in a year by all the member states, which countries and regions should be prioritized for resettlement, and which procedures should be used while these resettlement processes. And following this plan, the Commission is to adopt a more detailed plan which should be implemented by the member states. And this is called targeted union resettlement schemes. When both the Council and Commission would adopt these schemes and plans, member states are responsible for conducting resettlement procedures and to resettle persons. However, I must say there is no mandatory resettlement element in this proposal. So member states, even this proposal is adopted as is, will not be obliged to offer resettlement to any of the refugees, but they are urged to contribute to the union's effort to provide resettlement. And there is no distribution key or resettlement quota for each member state. So just bear in mind this. And then we look at 3 criteria that I determined who gets resettled. Now, this is one of the most criticized aspects of the proposal because it is quite different than the UNHCR criteria. Article 5 of the proposal regulates eligibility for resettlement, and according to that, there's a 2-tier test. The first one is for targeting resettlement, we need to determine that a person would normally qualify as a refugee or a person eligible for subsidiary protection as defined by the Recast Qualification Directive. However, besides that, internally displaced persons who are forced to flee inside their country of origin, persecution on the convention grounds, or serious harm may also be eligible for resettlement. This is criticized by UNHCR, ECRE, and a number of scholars on the basis that this blurs the line between resettlement and humanitarian evacuation. And UNHCR criticized it, saying that if I am to facilitate resettlement practices, since this is not in line with the UNHCR resettlement criteria, there will be practical challenges in resettling IDPs. So if we establish that a person actually satisfies the first criteria, the second thing to look at is that whether this person is vulnerable. And in Article 5, mostly UNHCR resettlement criteria are replicated with the exception of socioeconomically vulnerable persons. So all the criteria you're seeing in this slide, including women and girls at risk, persons with legal and physical protection needs, they're all UNHCR resettlement submission criteria. But socioeconomically vulnerable persons, which can be accepted as a new resettlement category and vulnerable person category, is modeled after the EU-Turkey Statement Operating Procedures. The proposal does not define that, and we don't know who can fall within the scope of this group. So I personally have an opinion on this, and I think that perhaps European Court of Human Rights Article 3 cases might be followed, such as MSS and Tarakel, but as long as the proposal clarifies this point, there is a wide place to interpret what socially economically vulnerable person means. A person, as I mentioned, should be either vulnerable or she or he can be a family member of a third country national or a stateless person legally residing in a member state, or he or she can be a family member of a union citizen. Now, this criteria has also been criticized a lot because those of you who are working on EU law would realize that this overlaps with the scope of the EU Family Unification Directive. So this means if the proposal is accepted as is, a person who can qualify for family unification under EU migration laws would be also eligible for resettlement. So this will take resettlement places, valuable places from persons who are really vulnerable and who has no other means to come to the EU legally. So this is one of the criticized aspects of the proposal. And the second aspect to look at is which status do resettled persons get in the member state if the proposal is accepted. Now, this would depend on which resettlement procedure is followed. I must say the procedure is to be determined by the Council and then the Commission, but mainly the Council. So the Council can determine whether for evacuation from, let's say, for Iraqi or Syrian refugees from Turkey, an ordinary procedure should be followed or an expedited procedure should be followed. What you need to know is if the ordinary procedure applies, it can take up to 1 year. Then resettled persons, if they qualify for the refugee status under EU law, then they will get a renewable refugee status in the member resettling state and a renewable resident permit, which must be valid for at least 3 years. And if the person qualifies for the subsidiary protection status in line with the qualification directive, they will receive a renewable resident permit, which must be valid for at least 1 year, and this is also renewable. And cessation of these statuses would also depend on the provisions of the qualification directive. I must say, if resettled persons, refugee or subsidiary protection status holder, lives legally for 5 years in the Union and satisfies additional criteria mentioned in the long-term residence directive, they may apply for long-term residence status and may get somehow a permanent solution in the member state. But for those of refugees and other persons in need of international protection who are resettled under the expedited procedure, they can only be granted subsidiary protection status. And this is quite problematic in a sense that this is a procedure which is foreseen to apply in humanitarian mass influx situations, humanitarian cases, so on and so forth. But the Commission makes a very strange exclamation point in the explanatory memorandum, and that is, the Commission urges those who are resettled under the expedited procedure to once again apply for international protection in the member state they are resettled. I mean, this comes a bit strange when you look at resettlement as a durable and permanent solution, but the proposal is also silent on what would happen to a person who is resettled under the expedited procedure, but who has received somehow a negative international protection decision in the member state. Will her or his status then be seized? Will he be sent back to where he came from? So we don't know that. So as to conclude, and this certainly builds on Maria's work, her book, and Nick's recent paper, that cessation of the refugee status of a resettled refugee, as long as it is in line with Article C of the 1951 Convention, may not necessarily present a legal problem, provided that the resettled refugee or the person does not have strong links with the host society or family links in the resettlement state, although it raises questions as to permanency, durability, and humanitarian character of resettlement. Imagine a person, an Iraqi or a Syrian refugee, waiting to be resettled in Turkey for 7 years. And then finally, when he or she gets resettled in Europe, Canada, Australia, imagine that her or his status or permanent residency is seized on the basis that there's a slight change in the country of origin. I mean, this certainly casts doubt about whether we see resettlement as a permanent or a durable solution. And you may think, but this is only a proposal, it's not even adopted. Why she makes this claim? I think this is closely connected to what Nick has just argued a few minutes ago. Nick just explicitly mentions that Denmark recently subjected more than 30 resettled refugees from Somalia to cessation proceedings. This, besides or together with the problematic and legally problematic aspects of the EU Commission proposal for resettlement, in my opinion, signals a trend towards restricting permanence and durability that resettlement provides. So these are only two cases, and I'm really curious about whether there are other examples, perhaps from where you are coming from as participants. If you know any example like this, please do come and say it. I'm very interested. But what I want to conclude is that if this continues and the cessation practices and the cessation of even resettled refugees status is withdrawn easily, or even if they are in line with the Refugee Convention, it raises doubts, or it makes me question whether resettlement is still a durable or a permanent solution. Thank you.
Thank you so much, Meltem. That was a very intriguing presentation and great for bringing resettlement into the picture, asking the question, if I had to summarize it, what is it actually? Is it a form of protection, or is it a form of a solution? I think you've answered that question. By looking at the Commission's proposal, the European Commission's proposal. And it's, I guess, on a personal note, worrying to see that the way this proposal is now formulated, that resettlement is a form of protection, a temporary solution, you call it, but certainly not a durable solution. This concludes the presentation. So the floor is open for discussions. We have quite a few questions being posed in the chat. We have about 20 minutes left. And I guess the best way of going about is for each of the presenters to give you the floor and respond to the questions. I will not try and summarize the questions. The questions are rich. They go into all directions, all the points that you've raised. So maybe we should just start with the order as you presented in. So Jessica, the floor is yours to give a response. Thanks.
Thank you. I noticed there's quite a number of questions here with my name on them, so I'll kind of prioritize those. The first question is what the first part of Article 1C, 1 through 4, tells us about notions of protection and nationality. Those clauses, cessation clauses, relate to what are sometimes referred to as voluntary acts of the refugee. So if a refugee has done something proactive to re-avail him or herself of protection of either the country of origin or another country in which he or she has effective nationality, then cessation can also be applied. I think that's really interesting. Of course, in my short presentation, I focused on the cease circumstances, but one thing that we also see in these practices of increasing temporariness are that safe return reviews also investigate questions under 1C, 1 through 4. There was a practitioner in the UK who told me that suddenly people are being met with really strange random questions about when they've traveled to their country of origin or another country even, and for what purposes, for how long. And these questions are kind of shifting focus in someone when they apply for permanent residence. So, so cessation practice is including this. And what I think I would say conceptually is that what this shows us is a kind of elision from kind of a focus on national protection to more of a focus on a person's attachments. So whether that person's attachments are related to their family life in other countries, or whether they're based on assumptions about networks in other places. I think that those kinds of issues are becoming more prominent and taking the focus away from a very sort of dogmatic approach to state protection. I don't know if that is helpful, but the question also asks the notion of durable solutions. What are the implications of that? I think Maria did a great job of explaining the kind of ways in which durable solutions are protected by the convention itself and how they're conceptualized by the actual convention, including through the articles of the convention, but also citizenship theory. In my own work, I've been kind of inspired by more empirical research on voluntary repatriation and trying to think about ways in which cessation can be, how is the outcome of cessation actually a durable solution and sustainable for refugees who are returned. And there I think that some of the interests and rights that ethnographic researchers have unveiled about processes of a voluntary repatriation and the emphasis on, let's say, mobility, on property rights, on family reunification, these kinds of interests that are kind of critical to someone's ability to restart their life in a sustainable way are helpful in thinking about how to conceptualize cessation within a broader durable solutions framework. And then there's just one more question I wanted to briefly touch on. Someone asks about the recent CJEU decision, SSHD versus OA. This was the decision where the court said that clan protection, I think, or protection by non-state actors doesn't qualify as protection for the purposes of cessation. And yes, this was decided very shortly before the Norwegian Supreme Court decision was not part of the materials that were presented before the court. Not that Norway is bound by the CJEU, but in any case, it was not part of the legal picture. But I also wonder if it really is that relevant, because in the Norwegian case, the court only implicitly endorses non-state actors of protection. It's more of like a very kind of superficial assessment of protection by Afghan authorities in Kabul, which is only accessible through a family network. So it's more about this kind of compound protection approach that encourages courts to not really investigate into whether protection is actually effective in the country of origin. I think I'll let Maria continue.
Thank you, Jessica. In the interest of time, immediately pass the floor on to Maria.
Thank you so much. So going from the top to the bottom of the questions, yeah, Ruvi, thank you. He talks about siloing of refugee pathways. Again, I can speak to the Australian example, those on a temporary protection visa and those who've come as a boat arrival. Everyone probably knows that in Australia we have a strict demarcation between those two cohorts, boat and plane arrivals. Those persons on a temporary protection visa can't access other sorts of migration visas. So the refugee pathway is siloed, as Ruvi has indicated. There are some special humanitarian refugee holders who can access other migration visas, but for the most part, the cohort who are subjected to these temporary protection visas can't access other migration visas, and that is a problem. Susan talks about the notion of effective nationality, and thanks, Jessica, for answering that. And if I go back to the work of Graeme Madsen back in 1966, he very much talked about this notion of effective protection, which I also talk about in my book. This idea that once you have recognised a person as a refugee, there is a higher burden of proof, if you like, for the state to then disprove that they're a refugee or to take that refugee status away. So Susan's point goes to that idea that a fleeting visit back to the home country or a re-availment of other sorts of national protection does not meet that threshold of effective protection. Omer Vertical, thank you so much for referring to Article 8 of the ECHR. That's really interesting. So I just took that as a comment. Dalal asked about the agreed model of integration. And yes, I think there should be more consistency, as long as obviously it's, you know, the guidance would be at a high level. I just want to flag one thing, and again, it's mentioned in my book quite briefly. One of the problems in, I guess, adjudicating integrative links on a public level by, say, looking at political participation, buying a house, having work rights, these are sort of public-facing integration links. And my concern as a feminist is that some female refugees living in a host state may not perform those sort of public facing integrative links, and they might be disadvantaged. So I would just, I guess, have a caveat as to how we adjudicate those integrative links. Eric Fripp asked a very good question about Article 12.4. I haven't looked at that, and that's Article 12.4 about nationality and the Human Rights Committee. So we're looking at the ICCPR. I agree that there is a divergence in the Human Rights Committee case law on that, but I do think we can draw on those general principles, the general principle being that after a period of time, either 5 or 7 years, a refugee in the asylum host state views that country, like Australia or the UK, as their own country, and therefore we can utilise ICCPR Article 12.4 principles. Thank you, Eric. I'll pass to Nick, I think.
Yes, thank you. Thank you, Maria. Nick, over to you.
Thanks, Maria. I'll pick up on two questions. One raised by Ruvi, who asks about the criteria for cessation with respect to convention refugees on the one hand and complementary protection holders on the other. And I guess I would put to you that there's at least a couple of possible views here. I mean, one view, of course, would be that convention status should be reserved for, you know, a sort of a particular group, in line with Article 1A2 of the Convention, and sort of gives a particularly special status given the well-founded fear of persecution. That is sort of qualitatively separate from the more generalised complementary protection standards. Another view, of course, would be to say, well, if you look at who gets protection across both statuses, I mean, we're talking about a largely similar group of nationalities, group of profiles, refugees fleeing conflict, for example. So you could make an argument for a sort of a more consolidated or at least close-sitting cessation standards. In my mind, at least, I could conceptualize sort of three sort of stairway of standards here. The first would be something in line with the Article 1C itself, borrowing directly from the convention. The second would be a sort of middle way approach, whereby some measure of legal certainty, stability, and recognition of integrative links is set down in law. And a third, which is what we see, I think, currently in Denmark, is this sort of absolute minimum protections, simply relying on Article 3, which, as I've mentioned, I think is inadequate. And I take your broader point about incentives on the part of states, but that might leave it for this discussion. On to Thomas's question, which is addressed to all of us. Thomas is asking essentially, is it reasonable for us to focus on this rather narrow set of states applying very divergent cessation standards, and is there an argument that the convention standard should apply? And this, in a way, gets back, Thomas, I think, to a question of, well, what sort of state practice do we have here? Is the state practice vis-a-vis cessation that we've represented on this panel the whole picture, or are there a bunch of other states carrying out cessation in line with the convention? I don't have a sort of definitive answer for you, but what I would suggest is that what we've discussed today does represent a pretty significant level of state practice, actually, because not many states do cessation, in my view. And what I would point to in terms of diverging standards here is actually a sort of design flaw in the complementary protection regime. So if you look, for example, at New Zealand's legislation, it states up front that as soon as a person is with complementary protection, no longer has a fear of refoulement, then this protection ends. And the difference here, of course, is that the New Zealand government is currently not utilising or instrumentalising its legislation to, in fact, carry out cessation. So I think for up until fairly recently, there's been an assumption of the application of the convention standards vis-a-vis complementary protection holders, and that assumption is now being very much removed and changed. Thank you.
Thank you, Nick. Over to Milton.
Okay, thank you for the questions. I will try to address two main questions that is addressed to me. So starting from Ruby's question, he asked me whether there is a temporal dimension to the legitimacy and plausibility of subjecting resettled refugees to cessation. If I understood correctly, whether if we seize the protection status of a resettled refugee after 1 year, would it be more legitimate than seizing the status of a person after 10 years? And this is what I understood from the question. And I think, yes, there is, because this is also touched by Maria, because when I was writing the book on temporary protection, not in the case of like national statuses, but temporary protection and mass and fluctuations, I was looking at, for instance, when to withdraw temporary protection so that people can access to durable solutions. And here, what Maria just mentioned, that 5 years is generally accepted somehow time limit for building integrative links to the host society. So I think seizing or withdrawing the status of a resettled refugee after 10 years is different than just withdrawing refugee, the status or a residency a person has come to the union, let's say, after 1 year. But we should bear in mind with this resettlement, it is really labor intensive. So refugees wait 4 years in the first countries of asylum to reach that solution. And imagine that even if this is like expedited procedure, this is done in 6 months to 1 year, this asylum seekers or refugees are already in the first countries of asylum for a long time. They're subjected to really detailed and complicated procedures. They try and they prove that they are vulnerable among refugees, and then they can get resettled. I think withdrawing the status of refugees, even after 1 year or after a short time, it is, as Maria mentioned she has a really good blog post in 2019, it is counterintuitive. And it damages the humaneness and durability of resettlement as a durable solution. I mean, yes, there is a difference between seizing it after 1 year or 10 years, but I don't think seizing after 1 year is still legitimate. So hopefully this answers Ruby's question. And Susan has a great question, which is generally about whether I have considered private sponsorship and whether it replaces or changes the utility or the outcomes of resettlement. I think private sponsorship and community sponsorship is a very good initiative. I mean, in the Global Compact on Refugees, it is endorsed, although I think there's a miscommunication or a confusion between durable solutions and the complementary pathways in the GCR. The distinction should have made clearer in my idea. But I think although community sponsorships and private sponsorships are very good initiatives, the number of persons resettled through these initiatives is very low. And therefore, I think it is a bit early to consider the replacement or a surrogate resettlement initiative. And I think when this is led by not states, by communities, although this is a very good thing, I don't think it will replace at any time soon the status of resettlement or offer millions of people a chance to a permanent solution in the host states. I hope I understand your question clearly. And since my esteemed panelists addressed other questions, I don't think I should go into that, and I thank you.
Thank you so much, Meltem. We are closing towards the end of this session, so there are still a few questions unanswered perhaps, but I would like to give the panelists each 1 more minute for kind of closing remarks. So Jessica, may I start with you?
Sure. I think I just wanted to, I mean, there have been a number of questions in the panel just pointing out the fact that that even sort of core principles of protection are routinely being violated, leading to forced returns, including, for example, there is from Asaf Blair, an aid worker at Nakivale refugee settlement in Uganda, is pointing this out. So I think in terms of the temporary quality of protection, of course, there are degrees, and from our perspective, exploring the state practice in the global north, of course, the concerns are more sort of systemic in terms of how the Refugee Convention is being perhaps eroded and pulled away from its sort of core principles. And the question of whether is this necessary to kind of maintain its relevance in a way? And I think that's kind of a question that Nick was pointing out, the fact that human rights law in so many ways has kind of overwhelmed the specialized function of refugee law and the specialized function it's traditionally played in terms of interpreting the rights and obligations towards refugees. And this is becoming sort of taken over perhaps by a human rights model, which was what I was trying to point out with my comments on surrogacy. And this is something that I think that we should continue to keep an eye on and question. So that's my final comment.
Nick? Oh, sorry, Maria, over to you. Sorry, Maria.
Thanks, Kays. I guess my final 1 minute point, and this perhaps relates to Thomas's point, and Thomas, yeah, it's a good question about how we treat the jurisprudence of a limited number of countries. I think Australia has probably been a little bit more influential. I know that the UK is trying to emulate some of our policies, and that's an unfortunate thing. I would say that one thematic thing is the use of temporary protection as deterrence in Australia, and I think that again is being replicated in the UK. But just in closing in 30 seconds, I think it all comes back to a good faith interpretation of the convention. And one part of me wants to recognise the state's interests in having temporary protection, and the theory is it's some sort of revolving door, and the more people we can give temporary protection and then cease it and return them to their country of origin, the more a state can bring in fresh refugees. That's the theory. The other side of me wants to argue for the strict letter of the Refugee Convention, which talks about Article 34 and the acquired rights. So I think in this space, we do have to consider the state interests in not giving permanency, but also look at really what the convention says.
Thank you, Maria. Nick?
I'll just conclude with a couple of arguments along my previous lines around why cessation for complementary protection holders should be very much based on existing refugee law standards. So firstly, of course, it would a very close cessation regime between the two models would allow for comparable standards for all protection holders. At the normative level, it would sort of allow for a two-way street, which Jessica has mentioned, between human rights law on the one hand and refugee law on the other hand, as sort of a living interaction between those two regimes. And hence returning to my concept of being cessation in the shadow of the convention, very much influenced by the convention. And finally, of course, for clarity and certainty for both state governments and refugees, a clear and comparable cessation model between refugee status and complementary protection status is desirable. Thank you.
Thank you, Nick. Meltem, final words for you.
Right, and I want to touch upon the question, what can we do to make it better in the last 1 minute? So this is not an easy question, but limited to my presentation, I think we need to reconsider the EU proposal on resettlement. The Parliament's report has really good suggestions on giving permanent residency and unlimited residence permits to resettle refugees in the EU. This can be followed. But in relation to the general cessation clauses, and perhaps this is one of the things that Thomas mentioned, a few countries implying the cessation grounds, does it make it a model for all the states? Will all the states follow these bad examples? And some will do. But I think this also is closely related to the yesterday's discussion on whether we should inject life to the 1951 Convention. And I think if the UNHCR does its supervisory role a bit better and perhaps utilize more modern techniques to make sure that states do not undermine the 1951 Convention, perhaps some of the problems we have today might not be future problems. Thank you.
Thank you so much, Meltem. Well, this concludes our panel. Thank you so much, first and foremost, to the presenters. Without you, we would not have had such an interesting discussion. Thank you also to the participants for your questions, your thought-provoking questions, and I think we could have gone on for many, many hours with this panel. Thank you finally to the organizers for having us and allowing us to give these presentations. Two things to end with. One is that when it comes to cessation, you may be interested to know that UNHCR is planning to start updating its guidelines on international protection on cessations, which number 3, which are quite old. That will be a long process, as usual, I should almost say, but it is coming, and you've certainly given us food for thought.